Comparison between motive and intent.
Motive. The moving power which impels one to action for a definite result.
Intent. The purpose to use a particular means to effect result.
Motive. Not essential element of a crime, and hence need not be proved for purposes of conviction.
Intent. Essential element of a crime. Motive is important in the following.
Where the identity of a person accused of having committed a crime is in dispute.
When there is doubt as to the identity of the assailant.
In ascertaining the truth between two antagonistic theories or versions of the killing. Where the identification of the accused proceeds from an unreliable source, and the testimony is inconclusive and not free from doubt.
Where there are no eyewitnesses to the crime, and where suspicion is likely to fall upon a number of persons if the evidence is merely circumstantial. To prove motive, motive is established by the testimony of witnesses on the acts or statements of the accused, before or immediately after the commission of the offense. Criminal liability. Article 4.
There are two situations contemplated under this article, whereby criminal liability shall be incurred.
Committing a felony, delito, although the wrongful act done be different from that which he intended.
Performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment, or an account of the employment of inadequate or ineffectual means.
Coverage of first situation.
The first situation covers even the following.
Error in personae or mistake in the identity of the victim.
Mistake in the blow.
The consequence exceeded the intention. Note, in these three circumstances, the offender is always liable. Example of mistake in identity.
X intended to kill Y, so he waited for the latter to pass in one corner. When a person resembling Y was approaching, X suddenly fired his gun, hitting and killing the person. It turned out to be Z.
Effects of error in personae.
The offender is liable for the crime.
Article 49 of RPC applies, that is, when the crime intended is more serious than the crime actually committed, or vice versa, the penalty of the crime bearing the lesser penalty will be imposed. But it will be imposed in the maximum period. Example of mistake in the blow, X fired his gun upon B. Because of poor aim, it was C who was actually hit. Note the following possible effects of the crime. Upon B, attempted homicide or murder. Upon C, if C was killed. Homicide and cannot be murder, as there was no intent to kill C. If C was wounded, physical injuries, serious, less serious or slight physical injuries, as the case may be. There cannot be an attempted or frustrated homicide or murder, because as far as C is concerned, there is no intent to kill. Possible charge. Complex crime, Article 36. Attempted homicide or murder with serious or less serious physical injuries, if C was seriously or less seriously injured. Two crimes, attempted homicide or murder, and slight physical injuries, if C suffered slight physical injuries. Effects of mistake in the blow.
Generally gives rise to complex crime.
If there is complex crime, the penalty to be imposed is the penalty for the more serious crime, in the maximum period.
There cannot be a complex crime when one of the felonies is a light felony.
Note, grave, less grave and light felonies are discussed in Article 9. Example of consequence exceeding the intention. G delivered a fist blow upon H. H fell to the ground and hit his head on the pavement, causing hemorrhage and eventually his death. G is still liable for the death of H, although his intention is merely to give a fist blow. Effect of consequence exceeding the intention.
It is a mitigating circumstance, particularly covered by paragraph 3 of Article 13.
Requisites of first situation.
That an intentional felony has been committed, and
that the wrong done to the aggrieved party be the direct, natural, and logical consequence of the felony committed. Suggested readings.
Examples of wrong done must be the direct, natural, and logical consequence of felonious act.
Examples of proximate cause.
Cases where there is no efficient intervening cause.
Cases where there is no direct, natural, and logical consequence of the felony committed.
Cases where there is no proximate cause.
Requisites of second situation.
The second situation talks about impossible crime. It has the following requisites.
That the act performed would be an offense against persons or property.
The offender is liable for the crime.
That its accomplishment is inherently impossible, or that the means employed is either inadequate or ineffectual.
That the act performed should not constitute a violation of another provision of the revised penal code.
Felonies covered in impossible crime.
Felonies against persons.
Felonies against property. Felonies against persons.
Parricide, Article 246.
Criminal liability, Article 4.
Homicide, Article 249.
Infanticide, Article 255.
Abortion, Articles 256 to 259.
Duel, Articles 260 and 261.
Physical injuries, Articles 262 to 266.
Rape, Article 266A. Felonies against property.
Robbery, Articles 294, 297, 298, 299, 300, 302, and 303.
Brigandage, Articles 306 and 307.
Theft, Articles 308, 310, and 311.
Usurpation, Articles 312 and 313.
Culpable insolvency, Article 314.
Swindling and other deceits, Articles 315, 316, 317, and 318.
Chattel mortgage, Article 319.
Arson and other crimes involving destruction, Articles 320 to 326.
Malicious mischief, Articles 327 to 331.
Examples of impossible crime.
When one tries to kill another by putting in his soup a substance which he believes to be arsenic when in fact it is common salt.
When
X
one
fired
tries to murder a corpse X with intent to gain, took a watch from the pocket of B when X had the watch in his possession, he found out that it was the watch which he had lost a week before.
An employee who, having known the safe combination, opens the safe in the office for the purpose of stealing money, but who finds the safe empty.
X, determined to poison B, uses a small quantity of arsenic by mixing it with the food given to B, believing that the quantity employed by him is sufficient. But since in fact it is not sufficient, B is not killed.
X tried to kill B by putting in his soup a substance which he thought was arsenic when in fact it was sugar. B could not have been killed, because the means employed was ineffectual.